Good afternoon. Thank you all for coming. Charlene and I are going to talk to you about some matters in relation to largely fiduciaries, disclosure, duties and diversion of opportunity. The scope of our talk is set out on that first slide with decisions in Friend Media and Guy Carpenter in recent months. You could be forgiven for thinking that it's tough times for claimants in team move disputes, and we hope to restore some optimism in the course of our talk. I'm going to look at some developments in relation to the duties of fiduciaries and in relation in particular to diversion of business, where there are several recent appellate cases which show a hardening in judicial approach to fiduciary breach, in particular the Supreme Court case of Recovery Partners from last year. And there are some interesting threads which I'll draw together in relation to remedies and discuss their implications for employment advisors. And Charlene will address the important question of what duties of disclosure may exist for fiduciaries and employees alike whilst in post. So why am I talking about fiduciary duties when we're employment lawyers? Well, of course, fiduciary duties can arise in several ways in the employment context. First of all, as a direct feature of the employee or worker's position, if he or she is a director or a partner, and then by reason of their position, if it's one of seniority and influence, or if the employee has specific responsibilities, works on a particular project, a particular client account that gives them a particular influence and control over an aspect of the business, the customer services and ransom model. Fiduciary duties, as you know, span a range stemming from the duty of single-minded loyalty, and the particular ones that are touched on through the cases that I'll speak to today is the duty not to make a secret profit and the duty not to allow a conflict of interest to arise between the fiduciary's interests and the interests of his or her principal. And the relevance in employee competition cases can be seen particularly in a team move where, for example, to take the paradigm of a desk up and moving from one brokerage to another, the desk head may very well be a fiduciary because of their seniority, their influence over not only clients, business connections, but also over the members of the team. Or a director who takes contracts and business and diverts them to a new company. The case of Recovery Partners in the Supreme Court last year arose out of the appointment, first of all, of Recovery Partners to assist in tracing assets of a Georgian billionaire who died unexpectedly and inexplicably without a will. The defendants worked as senior office holders in Recovery Partners and had fiduciary duties. The relationship soured and the defendants left, planning and then after their departure taking the contracts from the billionaire's estate to search for and recover the various assets. And obviously this led to findings of breach of fiduciary duties. At first instance, Mr. Justice Cockerill upheld the claim for breach of fiduciary duties, held that they were liable, the defendants were liable to account to the claimant for the profits that they've made, and allowed a 25% equitable deduction for their work. So $134 million plus interest being awarded. The case went up and it arrived at the Supreme Court, and because of the importance of the issues that were being raised, it was heard by a panel of 7 justices. The particular points of importance were that the defendants invited the Supreme Court to depart from the orthodox position in relation to fiduciary duties and the strict liability of fiduciaries established in cases like Boardman and Phipps, those cases that we all studied at university, which told us that even where the fiduciary acts innocently in making a secret profit, even where the fiduciary makes a profit that the principal would not have been able to make, there will still be strict liability. At the Supreme Court, the court was split. Lord Briggs gave the decision of the majority, and Lord Leggatt made some important minority points, which I'll turn to in a moment. The orthodox position of strict liability was affirmed very, very clearly by Lord Briggs. He said the fiduciary has a duty of single-minded loyalty, and explained it's a duty or obligation imposed by equity on all fiduciaries as an inherent aspect of their undertaking of single-minded loyalty to their principles, and that the fiduciary must account for profit that it has been made out of or from his fiduciary position and not keep it for himself. And the deterrent principle underlying this duty was emphasised several points through Lord Briggs and other judgments. The defendants appeal that a but-for causation should apply rather than there being strict liability, that courts should look at whether the principal could have made the profit for him or herself, was rejected. That it may be or appear to be unfair to innocent trustees, it may appear to lead to windfalls, it may appear to be cumbersome and outdated. Those positions were rejected in favour of the clarity and the prophylactic effect of the strict liability rule, and the Supreme Court expressly acknowledged the potential rigour and potential strictness of that rule in application. The Supreme Court went on and explained that far from being a but-for causation, requiring a sort of counterfactual as to whether or not the principal could have made the profit itself, the causal link was actually quite wide, and that what would be sufficient to satisfy a link between the fiduciary's breach of duty and the opportunity of the principal that had been taken, or the secret profit that had been made, was a link or nexus or reasonable relationship. So a much wider form of link is sufficient to found the link from breach of fiduciary duty to liability to account for the secret profit. So what then will be a business opportunity of the principle that cannot be taken by the fiduciary? Well, there are obvious cases where the business is diverted while the fiduciary is still employed or engaged, as a director who siphons contracts into his or her own company. There's, of course, a penumbra where the fiduciary is preparing to compete, and the Court of Appeal in the Cheshire case I cite on the slide has upheld the long-established understanding that there's a spectrum and there's no hard and fast rule. It's always a highly fact-sensitive analysis as to what point preparatory steps take the fiduciary across the line and mean that the fiduciary can no longer carry out their duties properly and loyally. But once the fiduciary resigns and once the relationship is terminated, he's free to compete. However, where there is a maturing business opportunity, there will be liability even beyond termination of the relationship. That was explained in Recovery Partners. The logic of that was explained that there is, in effect, a breach of that single-minded loyalty. If the fiduciary plans, as the defendants in Recovery Partners did, plans to resign and then take advantage of opportunities that they've become aware of during their role. And there'll be liability for the profits obtained by the diversion of opportunity. Lord Leggatt considered this in some detail. He considered that there can be a point at which business information is capable of being considered property of the company and worthy of protection. And that information about a business opportunity acquired by a fiduciary can be treated and protected as property. And a maturing business opportunity is property of the principal if it comes and therefore cannot be exploited even after the termination of the relationship, if it's come to the knowledge of the fiduciary during the course of their role, and is an opportunity that the principal was actively pursuing. I mentioned the case of Titanium and Hughes on the slide, and that's in the partnership arena, but it's a very interesting, quite detailed example of how the court will analyse a maturing business opportunity. There were 18 different opportunities analysed by the court in that case, and the court was examining whether what was done by the fiduciary after termination was materially the same as the business opportunity that was pursued by the company before, and whether actually the company was pursuing it as a business opportunity, or whether there was a less specific and more general marketing or hope that some form of business would arise in the future. But always, remembering the rejection of but-for causation, always the company's actual prospects of getting the opportunity and making any money for itself are immaterial to the construction of liability and then the secret profit that can be recovered from the miscreant fiduciary. These cases and the affirmation of the strictness of the rule brings into fresh light a case from 2020 that's of particular interest to employment lawyers, the case of Gray and Global. It's a case in the oil and gas sector, but it's of interest to us because the court held there that remuneration could amount to the secret profit that was recoverable from the fiduciary. It's a complex case, but in effect, Gray was a man with two governors. He worked for Global Energy on the one hand, and he worked for an investment company on the other hand, and he allowed business opportunities to be diverted from Global into the investment firm. Global always knew about his two roles, but what Global didn't know was that at a point his remuneration with the investment firm was changed so that he was incentivized and was given various incentives based on essentially what he could divert to them, and was given carried interest in some of the profits on the investments that were hoped to materialize. The court had little hesitation in holding that there was a sufficient link, as they put it, between Mr. Gray's breaches of fiduciary duty to Global and his management fees paid by the investment fund. Similar approach was taken to Carey and also to a consultancy fee that he was paid. The Court of Appeal upheld that. The Court of Appeal also upheld the approach that the judge had taken in relation to the fact of Mr. Gray's own skill and labour. The judge had made a discount, first of all, for expenses in the course of his work, and had then made a discount to reflect the percentage in terms of his management fees, remuneration, the percentage that reflected his work on the diverted business as opposed to other unrelated work. But beyond that, the judge refused to award an equitable allowance to reflect his labour and skill. Mr. Gray had argued that he should have been paid or would have been paid a salary of £1 million a year, and that should be deducted from his liability, and the Court of Appeal put paid to that. The equitable allowance was a discretionary remedy, and the court was entitled to take into account the nature and extent of his breaches in refusing to exercise its discretion in his favour. So how does this apply in the context of employee competition? Well, if you've got a fiduciary who is recruited for their client book, or for the other employees that they could bring across, or for particular knowledge of a business idea or some IP, and components of their remuneration reflect that, or there are direct links into share options, carry, then that adds another dimension to the suite of losses, the suite of damages that can be claimed against them, and allows the employer to trace into amounts and recover amounts, even if it has suffered no loss and would not have been able to capture the opportunities for itself. Another factor in recovery partners that's of considerable importance is the apparently academic argument between the majority and the minority as to what the consequences are when a secret profit is made. The majority held that there's a fiduciary duty to hold that secret profit on constructive trust for the principal. So at the moment of making the profit, a new duty arises and a constructive trust arises as of right without the need for a court order. Lord Leggett took a different view and expressed in some ways the implications of the majority view. He said it was not just unnecessary but unsound to have a fiduciary under a duty to pay the principal secret profits without there being an order of the court. And this leads to open questions as to exactly how this will be able to be enforced in relation to third parties. I mean, certainly the very clear emphasis that a constructive trust arises upon the making of a secret profit takes the principal into proprietary remedies. So not just a right to compensation or a right to an account of profits which depend on how much profit has been made and how much profit is actually left, but a constructive trust being so that the profits are the property of the principal. I'll turn quickly to the next two slides before I hand over to Charlene. Dishonest assistance, I cite the Stevens and Hotel Portfolio case, which is slightly outside, I think, the usual employee competition case on its facts, but very interesting for indicating in the direction of travel and the strictness with which the courts will apply, strictness with which the courts will enforce the fiduciary duty and the rule, the profit rule, even against those who don't have fiduciary duties. There was a harsh decision made against Mr. Stevens in this case because it was justified by the paramountcy of the need to preserve the profit rule as a deterrent effect for breach of fiduciary duty. So even those who are involved in a team move who don't have fiduciary duties may well find themselves, if they have dishonestly assisted fiduciary breaches, swept up in the very strict application of the rules to the fiduciary. So turning then just to sweep up some implications for employment advisors, always worth considering fiduciary duties and dishonest assistance because of the strictness that's opening up in the law. Always worth looking at whether you can plead a constructive trust and whether it's arguable that profits amount to trust property. The key battlegrounds are likely to be whether the business diverted is an opportunity belonging to the employer, and what is the secret profit? Is remuneration made by the fiduciary, possibly by other members of the team, properly attributable to the breach, or is it properly attributable to other factors? Let me turn to Charlene to pick up.
Thank you, Lucy. Good afternoon, everyone. Hopefully I have caught you before the mid-afternoon slump, and hopefully you'll still be awake at the end of my 15 minutes. I'm going to be addressing you on disclosure obligations of departing employees. Now, as we all know, the law seeks to strike a balance between allowing employees to compete and protecting the employer's legitimate business interests. And the issue of disclosure obligations of departing employees involves the intersection of contract, fiduciary duties and implied duties, and in particular, the implied duty of good faith and fidelity. Why is this important? Because, as we know, employees are rather good at covering their tracks during employment, and the misconduct only is discovered after they've left. Now, recent cases demonstrate judicial reluctance to impose obligations beyond those expressly agreed in the contract, while remaining willing to grant robust relief where confidential information or fiduciary duties are involved. So I'm going to start by setting out the legal backdrop. I'll then address you on some of the relevant case law in this area. And finally, I'll briefly talk a bit about some practical tips when advising employers. Turning then to the legal backdrop. Now, I've summarised some of the key duties both during employment and post-termination in this table. It's the left-hand column that we'll be focusing on over the next 15 minutes. Now, there are essentially 3 different types of employees, as we all know. Each have a different level of disclosure obligation depending on their role and responsibilities. First, we have ordinary employees, or mere employees as they're often called. Secondly, senior employees, as Lucy said, who may be treated as fiduciaries in certain contexts and owe certain fiduciary duties. And finally, directors. And those are, as we know, they owe classic fiduciary duties under the Companies Act 2006, and in particular Section 172, the duty to promote the success of the company, which features heavily in this context. Now, these, of course, can be considered on a spectrum. You have the directing mind of the company at one end and the most junior employee at the other. As a general rule of thumb, the closer the employee is to the directing mind of the business, the greater the likelihood that a court will impose positive disclosure obligations. Now, of course, the duty of good faith and fidelity applies to both mere employees and fiduciaries and directors, but the scope of that duty varies across the spectrum of employees. Whilst it's true that ordinary employees owe a duty to behave faithfully, that in law falls short of the single-minded duty of loyalty owed by a director or a fiduciary to the company, requiring them to pursue the interests of the company in preference to their own interests. And it's that greater duty of loyalty in respect of fiduciaries and directors that has led the courts to impose stronger disclosure obligations at that end of the spectrum. Now, the starting point for any discussion on disclosure obligations is the seminal case of Item Software and Fasihi. Mr. Fasihi, in his role as director, encouraged Item Software to take a tough stance on negotiations with a client, while simultaneously and secretly writing to the client offering to take on the agreement himself through a new company he was intending to set up. Lady Justice Arden had something to say about that. She held that there was no separate implied duty to disclose misconduct, but it formed part of the director's duty to act in good faith in the best interests of the company. She held that, as Mr. Fasihi could not reasonably have concluded that it was not in Item Software's interest to know of his misconduct, he could not fulfil his duty of loyalty except by telling them of his misconduct. Now, crucially, the court in that case made no findings as to whether Mr. Fasihi would have been required to disclose his own wrongdoing if he had only been a mere employee, but she found that there was nothing in the preceding case law to prevent such a contractual duty arising in the case of the mere employee. Now, 2 important developments after Fasihi that are worth mentioning briefly. Firstly, in Tennard, the Court of Appeal held that there was no duty on an employee salesman to disclose lawful preparatory steps to compete, despite him owing some fiduciary duties. So again, all depends on the circumstances. And secondly, computer systems and ransom. Here the Court of Appeal held that mere employees owe no general duty to report their own misconduct or the misconduct of fellow employees, but, and importantly, said that that's not to say that such duty cannot be provided for in the terms of the contract of employment. Now, the position was neatly summarised in QBE and Dimmock at paragraphs 191 to 192 in reference to Paul Goulding's book on employee competition. Firstly, in relation to fiduciaries and directors, they owe a duty to disclose their own misconduct whenever they, in good faith, consider that misconduct is not in the best interests of the company, and they ought to disclose any competitive threats that they become aware of, whether due to their own actions or the actions of others. Mere employees, on the other hand, only owe a contractual duty to report the misconduct of other employees where such a duty can be inferred from the nature of the employment. So again, a stark distinction between fiduciaries at one end of the spectrum and junior employees at the other end of the spectrum, but junior or mere employees may owe such duties depending on the nature of the employment and the terms of their contract. Turning to some more recent developments, firstly Invenio and Goyal. Now this is one of the clearest recent examples of the courts applying fiduciary disclosure principles in a senior executive context. Mr. Goyal was a founder, director and chief financial officer of Invenio Business Solutions. The claims against him included misuse of company funds and accounting irregularities. And the court held that the fiduciary duty of loyalty includes a requirement to disclose one's own misconduct, and said this: "If I was in any doubt as the imposition of such a duty, I am entirely satisfied that it is the correct approach in circumstances where the failure to disclose was on the part of the finance director of the company in respect of matters having a financial impact upon the company. It need hardly be said that it is essential to the stewardship of the undertaking that the finance director can be relied upon to act with honesty and integrity in relation to expenditure and liabilities." The court went on to emphasise that the disclosure was necessary to allow the company to act in its best interests, including potentially dismissing Mr. Goyal and designating him as a bad leaver under his service agreement. So again, for directors and fiduciaries, silence itself can be actionable. Now, of course, this says nothing about mere employees because Mr. Goyal was a director, but the court's reference to the job role and responsibilities and the overlapping nature of the misconduct hints at what the position might be in relation to a senior employee in similar circumstances. If a duty to disclose can be inferred from the nature of the employment and the terms of the contract, then such a duty may also be imposed on mere employees. Now, turning briefly to the recent case of Guy Carpenter, and I say briefly because I know that Johnny and Matt will be addressing you on this in more detail later. The key points to take away from that case on the disclosure obligations of fiduciaries are as follows. Firstly, a restatement of the principle that the duty to act in good faith in the best interests of the company incorporates a duty to disclose one's own wrongdoing. Secondly, clarity that that is not, however, limited to disclosure of wrongdoing, but also extends to the reporting of competitive threats, which the fiduciary becomes aware of, whether by reason of their own actions or the actions of others. The court in that case also went on to say that such a requirement may also be part of the duty of fidelity held by a mere employee who is not a fiduciary. So again, pushing on that door in relation to mere employees and potentially extending the duty to disclose wrongdoing and competitive threats beyond directors and fiduciaries. And then finally, that senior employees and directors may also be required to take steps to thwart such threats. And I leave that there because I know Johnny and Matt will be talking about that later. So in the case of fiduciaries and directors, the courts focus on loyalty. The question is, was the fiduciary acting loyally to the company? But what does that mean and how is it assessed? Now, in the Saxon Woods case that I've cited on this slide, the Court of Appeal explained that in a commercial company, it is the directors and not the court who decide what the commercial approach for the company, what the best commercial approach for the company should be. And it is the directors that take business decisions, and the court will not interfere with that or find a breach of fiduciary duty simply because the court, or indeed anyone else, takes a different commercial view. However, Section 172 of the Companies Act 2006 contains a requirement of good faith, and the Court of Appeal in Saxon Woods summarised the position as follows at paragraph 122. The requirement that the director acts in good faith includes as a core fiduciary duty a requirement that the director acts honestly towards the company. And the test as to whether a person has acted honestly or dishonestly requires an objective assessment of the conduct of the relevant person in the light of the facts as they knew or believed them to be when they embarked on their course of conduct. So in other words, the duty of loyalty must be assessed subjectively but with an objective consideration of honesty. So the position in relation to fiduciaries or directors is somewhat clear, but where does that leave mere employees? Now, the earlier case of Blue Bay Asset Management provides some useful guidance in this respect, and I've set out that guidance on the slide. The content of the duty of fidelity is determined in the first instance by the terms of the contract. In relation to preparatory steps, where the boundary is to be drawn between what's lawful and what's not lawful, is often a difficult question. And although the authorities provide some helpful guidance, each case depends on its own particular facts. The duty of fidelity may also require the employee to report competitive threats of which he becomes aware, but again, each case turns on its facts. And some of the relevant factors that the court will consider are the terms of the contract, the nature of the employee's role and responsibilities, the nature of the threat, and the circumstances in which the employee becomes aware of it. So, for example, the employee that is aware of the competitive threat but positively misleads their employer may find themselves in some hot water, as the junior employee did in Kynixa. Now, back to the Blue Bay Asset Management case, the court also emphasised that an employee cannot circumvent the duty to warn their employer of a competitive threat by entering into a contractual duty with the rival, requiring them not to disclose to their employer. Now, that was somewhat ingenious, but also frowned upon by the courts. So I've set out here in this table some guiding principles, and the eagle-eyed amongst you will notice that there's lots of ifs and maybes in this table, but unfortunately such is the uncertainty of this area given its fact-sensitive nature. Generally, however, as I said at the beginning, the more senior the employee, the stronger the disclosure obligations. And in relation to preparatory steps in particular, there's a helpful table in Block and Brearley at 3.159, which sets out the sorts of steps that are permissible and the sorts of steps that are prohibited. And of course, if it's prohibited, then such conduct would be reportable by senior employees and directors, but may not be reportable by junior employees. Of course, again, depending on the circumstances. So finally, and very briefly, what practical tips can we take from this? Well, the key lesson here is always contract, contract, contract. Don't leave it too late. Sometimes it can feel uneasy to be thinking about these things at the commencement of employment, but it's important to include express obligations in the contract if you want to be protected against some of these things. So consider including express disclosure obligations in relation to, for example, solicitation attempts or competitive job offers. Companies may also want to include departure allowance clauses in contracts of senior employees to ensure that there isn't a mass exodus at any given time. And on that note, I will allow you all to have a mass exodus to the coffee bar. Thank you all for listening.
Thank you.